It is June 4th of 2026, and this is the Court Gallery. From a Doordash delivery that ends in a cemetery to a tenant whose temper cost him his apartment after he threatens the landlord will have a death on their hands. This docket is a masterclass in questionable decisions. We'll see bond hearings with some wild backstories with Judge Simpson, and it all wraps up with a defendant who celebrates getting off probation for DUI by getting another DUI that very same day. We've got Middleton, Holmes, Simpson, and Hesselink on deck today. Every case is a wild cautionary tale. And as usual, it all starts right now.
All right, good morning. We're here for a formal hearing in a traffic violation matter. Title of the case is The Village of White Pigeon versus Ryan David Rosansky. Is that you, sir?
Yes.
The file number is 266009960I1. For reasons I don't completely understand, the civil infraction cases have a real long number. Defendant got a ticket on April 4th, 2026 at 9 o'clock at night in White Pigeon at Vermont and Elkhart Street. The ticket was written by Sergeant Hanson, who is present here today, Matthew Hanson. He was cited with disobeying a traffic control device. That is a civil infraction in violation of 257.611. It carries a fine and 2 points. Rhonda, we're set for 9:30 for your matter. She should be brought over here. Yes.
Talk to her at the county jail, so.
Okay.
Just here a little bit early.
All right.
They haven't brought her yet, so.
All right. I'll see you in a little bit. Thank you.
No problem. Thank you.
Welcome back.
Thank you.
All right. Are the people ready to proceed?
We are, Your Honor.
Could you place your appearance on the record, please?
Yes, Your Honor. Good morning. Matthew Buck for the Village of White Pigeon.
I believe there was already a informal hearing in this matter.
That's
The
correct.
defendant appealed it, which is his right, and asked for a formal hearing in front of the judge. So that's where we are. So, Mr. Rosansky, are you ready to proceed?
Yes.
All right. Well, Mr. Hanson, why don't you come up here into the witness box, and I'll put you on oath, and we'll talk about this citation. I'll just stop right there for a moment. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief. Good. Take it off the overall view. Good morning. Would you state your name for the record, please?
Matthew Hanson.
And what's your occupation, Mr. Hanson?
I'm a police officer at the Village of White Pigeon.
You're presently a sergeant there. How long have you been with that department?
9 years ago. Sorry, 9 years in counting.
All right, 9 years and counting. I'm something like 47 years and counting. But who's counting? All right, Mr. Buck, you may inquire.
Thank you, Your Honor. So, Sergeant Hanson, you said you're employed as an officer with the Village of White Pigeon Police Department. Okay. And what is your I guess let me ask you this. On April 4th, 2026, were you in that role?
Yes, sir.
What are some of your responsibilities in that role?
Patrol the village, responding to calls, traffic enforcement.
Okay. And were you patrolling on April 4th?
Yes, sir.
Was that in the morning, in the evening?
In the evening.
In the evening. Were you on patrol around 9 o'clock p.m.?
Yes, sir.
And where were you patrolling at that time?
I was conducting directed patrol along West Vermont Street near Elkhart Street due
Okay.
to some recent reports of traffic issues at the stop signs from the apartment complex.
What kind of traffic issues?
We've had numerous complaints from the residents that the new apartment complex was failing to stop the stop signs and failing to stop the apartment complex.
Okay. So a directed patrol, and correct me if I'm wrong, is basically you're looking for, obviously you would stop any crime you see, but you're looking for a specific kind of crime. Is that fair to say?
Yes, sir.
Okay. And on that day, on April 4th, around 9 p.m., did you see, let me ask you this, what did you observe?
Around that time, I did observe a white Toyota passenger car, came up Bradley Street to West Vermont Street. It was going a little fast, just a couple miles over the speed limit, not a big deal. I did watch the vehicle go into the cemetery after hours, a little unusual. I believe it was someone from the vehicle went to the apartment complex. They were there for a few minutes and then they left. Upon leaving the cemetery, the white passenger car failed to stop leaving the private drive and then turned and continued westbound on Vermont Street, failing to stop the stop sign at Vermont and Elkhart Street.
Okay. And this intersection that you mentioned, is that in the village of White Pigeon?
It is.
Is that in St. Joseph County?
Yes, sir.
State of Michigan?
Yes, sir.
Perfect. Okay. So after you saw this vehicle pass the stop sign without stopping, what did you do?
I conducted a traffic stop.
Okay. Tell me how that went.
Identified the driver as Mr. Rosansky.
Yeah.
Mr. Rosansky. He was the driver of the vehicle. After my contact with him, I did decide to write him a citation for disobeying the traffic control device.
Okay. And you already kind of have done this, but is Mr. Rosansky in the courtroom today?
Yes.
Could you identify him and an article of clothing he's wearing?
He's sitting here with a white shirt.
Thank you, Your Honor. Would the record please reflect that Sergeant Hansen has identified Mr. Rosansky?
Yes, it may.
Thank you.
Which device was he cited for disobeying?
The stop sign, sir.
At which intersection?
West Vermont and Elkhart Street.
All right, thank you. You may continue.
Thank you, Your Honor. And disobeying a traffic control device, in this case, a stop sign, is a violation of state law. Is that correct?
Right.
Okay. I have nothing further. Thank you.
Mr. Rosansky, you've been through an informal hearing and I wasn't a part of that, so I don't know anything that happened there, but as in that case, you have an opportunity to question this witness if you wish to. Are there any questions you wish to ask of Officer Hansen?
Yes, actually, yeah, there's several questions. For just as starters, Mr. Hansen, can you clarify where exactly you were positioned at the time that you observed the alleged traffic violation?
About a block east.
About a block east.
Yep.
For the record, could you name that intersection?
It'd be St. Joseph Street in West Vermont.
Okay. Yeah, and we acknowledge that this was at nighttime. Where is the traffic? You're familiar with the area. Where exactly is that stop sign, and where is it pointed?
The stop sign would be at the intersection facing east.
Would be at the intersection facing east. And how when the geometry of said intersection is put into question, where is the exit of the private drive in relation to the stop sign?
It would be before the intersection.
It would be before or at?
Before.
I don't know. Do I have the ability to submit photo evidence? Because I don't I wasn't
Yes,
able to do that
you
during the
do.
photo.
What-
How do I do that?
What do you have?
Photo evidence of where the stop sign is.
Okay, what nature is the photograph on your phone?
Yeah.
Um, there is a way to do it, but I may just have to look at your phone.
Okay, that's fine.
I have no problem with that, Your Honor.
All right.
Okay. I got it.
This is an informal hearing. I mean, excuse me, a formal hearing, but it's a civil infraction. So the burden of proof is only a preponderance of the evidence. And there's no right to counsel or no right to a jury trial on a civil infraction. So Mr. Rosansky's been through this hearing once in the informal hearing before the magistrate. The law allows either party to appeal that, and that's what this defendant has done. So it is a little less formal than a regular trial. So I guess what we'll just do is look at his phone. Sergeant Hanson, what's the name of the new apartment complex that's gone in there?
Native Flats.
Nativeflat.
Yes, that sounds right.
Yes, Native Flats.
I believe it's owned by the same people who put the apartments in Centerville.
Yes, it is.
Just swipe up and right. Just swipe right. There's two pictures. The first picture would be a perfect snapshot of where the stop sign is located from the perspective at which I was approaching the intersection, and then the second would be from his view.
All right, what street is the car on from which the photograph was taken?
On which picture, one or two?
I'm only looking at one.
On one, that is the exit that's exiting the cemetery.
All right,
You can clearly see that the stop sign is not facing the graveyard.
all right. So you're going from the cemetery.
Onto the other intersection, which from his view would be the second photo.
Okay,
You can clearly see that the stop sign is not facing the cemetery. And if you turn into the intersection, once you arrive onto the intersection, your car is already past the stop sign. And there is no stop ahead sign anywhere to be found.
all right. I understand what your point. The cemetery is a private drive.
Yes.
He indicated that you didn't stop when you pulled out of there, entering onto the main roadway, but there is no stop sign facing that direction.
Exactly.
When you get onto the roadway, there is a stop sign which appears to be about 8 feet from the intersection. And all right, you've seen it, but you can look at it.
The second photo, the second photo would be from his view, not from my view pulling out.
Yes. I saw both pictures and I will accept them as evidence. All right, let's look at the screen. Let's see if I can figure out where we are here. Oops. Get all out of discombobulated here. All right, this is Vermont Street. Which way is the apartment? Am I headed toward the apartment complex?
No, you have to turn around.
All right. No, I lose the picture. Well, that doesn't help.
That would be the intersection.
Is this the intersection?
That looks like it. That is the intersection.
All right, so the cemetery comes out here.
No, it just it comes from the other way.
All right,
And
the cemetery comes out here.
no,
One to the right.
to your right. That's
All right, right
there
there.
it is. Yep.
All right, now there used to be just that apparently. So this is the drive coming out of the cemetery.
Yes.
You were
Stop.
coming this way. There's no stop sign from the cemetery onto
Yes.
Vermont Street. Is that correct?
Yes.
And then you were going to turn right down this road to go towards the apartment complex.
Yep.
Now, this is an old Google Earth photo, but it shows a temporary stop sign. So the stop sign in your picture would be
So somewhere
right about there. All right. So it's your contention that
My contention is that under
you came out of here and the stop sign didn't tell you to stop there. And then by the time you got here, the stop sign was already.
has already passed. So if under normal nighttime driving conditions, it is not visible enough to give a adequate time to respond to the sign. Therefore, a stop ahead sign would be required. However, I don't think that would be necessary because Michigan law says that you have to stop at all private drives, which I'm from Indiana, and that's not the case there. The requirement in Indiana is to yield unless you're turning left.
I'll stop sharing. Anybody else want to comment on any of this? The picture's not the greatest, but it does give a better picture that we can all see of this intersection. Looks like it was taken on a nice summer day. But at the time this was taken, that complex was not there yet.
Right.
All right, well, we'll stop the sharing.
There is now an actual stop sign. Not
Yes, we saw it in his picture. There's an actual stop sign at that location. All right, any other questions you wish to ask of?
I do not believe so at this time. No.
All right, thank you. You may step down. Your pictures better showed it than that Google Earth photo, but
I
that
took
was the best.
several. I just can't find the rest of them.
But that's the best we had. All right, any further testimony or evidence?
No, Your Honor.
All right, Mr. Rosansky, do you wish to testify?
Sure, why not?
All right. Why don't you just stay there, then I'll be
Okay.
able to see you more clearly.
Okay.
All right, you raise your right hand. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes.
All right, what do you want to tell me?
At this night, I noticed I'm unfamiliar with the area. I'm not from here. I'm from India. I was Doordashing with my girlfriend, and we were doing our last delivery for the night. I'm being
Doing a
unfamiliar. Say that again.
You did a word I didn't hear. Something delivery?
Yeah, Doordash.
I know, but you said you were doing a wrestle and delivery or something. I didn't understand what.
Oh no, me and my girlfriend were Doordashing, and it was our last order for the night. Is what we were doing.
All right, you were door dashing. That was your last delivery in
Yep.
the kitchen.
Yep.
Where were you delivering from?
I don't remember off the top of my head. I do hundreds of deliveries.
All right. Why did you end up in the cemetery?
I was unfamiliar with the area, and I went where the GPS told me to go. We deliver in strange spots all the time, so it wasn't necessarily unordinary to deliver to a cemetery, especially if there was like a security guard we were delivering to or whatever the case may be. But when I got up to the pinpoint, I was like, "Oh, it's an apartment." That's not. I don't see that being that big of an issue, especially because I'm already in the cemetery. So I delivered my order. I turned around. And I got back in my car, I got everything ready, and then I drove forward, I did a U-turn, and then I exited. As I exited, I hit that, I looked to my left, quick remember, I noticed I made a statement saying I was from Indiana. Our only requirement in Indiana when turning right out of a private drive is to yield. So I looked to my left, I didn't see anybody. And so I went on. I turned right and I went on. And then as I was driving, he initiated a traffic stop against me, and I stopped. During the traffic stop, he questioned me in regards to several matters, but he questioned heavily as to why I was in. His main focus was why I was in the cemetery. I answered accordingly, and then he asked if I saw the stop sign back there. I said no, I had no idea there was a stop sign back there. And after that, he wrote me a ticket saying that you blew a stop sign, even though I had no knowledge of a stop sign back there. And that's when I went back and took pictures. So I was like, is there really a stop sign back there? Until I went back and that confirmed, obviously, there's a stop sign back there.
All right. I didn't understand the sequence. I assumed that you were, I don't know, I assume maybe you went in the cemetery for a minute, then came out of the cemetery and were on the way to the delivery.
No.
But your statement is you'd already made the delivery?
Yes. The delivery was inside of the apartment complex, but it was a building that was right next to the cemetery.
All right, then you went back into the cemetery?
No. I was in the cemetery, and then I made the delivery because you just walk right across.
All right, so you stayed in the cemetery
Yes.
and made the delivery?
Yes.
All right, so you left your car in the cemetery, walked across the grass or something, made the delivery, got back in your car.
Yes.
All right, and you were coming back to your car, and then you were going to make a right turn.
No, and then I made a U-turn, and then I made that right turn onto Vermont Street. Okay.
All right, which would have taken you back toward the apartment complex?
Yes. Yes.
Where you did the U-turn inside the cemetery?
Yes, I did the U-turn inside the cemetery.
Okay. And then that Vermont Street would eventually get you back to US 12 or whatever way you were going to use to go back to Elkhart.
Yes.
All right. Does that raise any questions for you, Mr. Buck?
No, Your Honor.
All right, thank you. Anything further?
No.
Argument?
Thank you, Your Honor. I honestly have no doubt that Mr. Rosansky didn't see the stop sign. I think that's fair to say. He did, however, go through the stop sign without stopping. We heard Sergeant Hansen's testimony to the same. He observed Mr. Rosansky coming out of the private drive, turning right, passing the stop sign, and continuing on without stopping. It's obviously if that's a disobeying a traffic control device. I think it's pretty straightforward from there. I don't think that there has been any evidence that the traffic signal was improperly placed. I don't think that it would be appropriate. In fact, it isn't appropriate to put a stop ahead sign on a private property, in this case, the cemetery, to let you know that there's a stop sign around the corner. While these sort of, I guess, intersections aren't incredibly common, this is not an unforeseen thing. This where you have an immediate turn and a stop sign right after. I think it was an honest mistake, but he did violate the Michigan law, and I think that the village has met its burden.
Can I counter?
Yes, you have.
The manual on uniform traffic control devices is clear in its conditions that all signs must meet. It is clear that a stop sign must be facing the lane it intends to control and give notice. If it does not give notice, a stop ahead sign must be placed. However, we've made note that that failure to stop at a private drive that's what I failed to stop at a private drive. So that would satisfy the stopping requirement. I would say that the stop sign is improperly placed. I believe that it should be placed before the intersection, because when you are exiting the cemetery, all lanes of travel affecting the driver leaving the cemetery are visible from the cemetery.
All right. You raise an interesting defense. Here's the intersection again. This is a recipe for an accident if we use your theory. There isn't anywhere else to put the stop sign. The stop sign is to stop,
East, westbound travel.
yes.
And I was not heading west.
And they can't put a stop sign ahead. One thing that would perhaps help if they put a stop sign at the end of the driveway,
That's,
Like the
yeah,
cemetery.
that would be proper.
but that's private property. It's not state road. So the stop sign is to, this runs north and south or east and west?
Vermont is east and west.
All right. So it's to stop people going down Vermont Street from pulling or colliding with somebody coming off the north-south intersection. So there's a stop sign right there. But if everybody was able to do what you did, it would circumvent the whole thing. If you were able to just pull out of here without stopping and then go here without stopping, it would be a recipe for a collision in this intersection. Now, granted, it's at night, you're not familiar with the area, but if it didn't apply, it would be a way to just simply circumvent that stop sign.
That's where you would have the failure to stop at a private drive.
Yes. All right. Let's talk for a minute. The traffic control device, this little temporary sign here is not what was there. There was a fully posted state highway correct stop sign that you showed me in your picture. A traffic control device means all signs, signals, markings, and devices not is consistent with this act, placed or erected by an authority of a public body that has jurisdiction. So that qualifies. That one doesn't, but the one you showed me in your photograph does. So let's talk about the actual statute you're charged with violating, 257611. Tell you how old this is. The driver of a vehicle or operator of a streetcar shall not disobey the instructions of a, excuse me, traffic control device, which is that stop sign. That law was enacted in 1949, where apparently there were still some streetcars in the state of Michigan. So I understand your defense. I'm going to stop the screen share. Sergeant Hansen was there specifically under what's called directed patrol. Previously, there had not been any residences back there. It was a rural area, and they built an apartment complex. It probably has 50 or so units in it. So all of a sudden, there's a lot of traffic coming up and down this road where there previously wasn't any. So you have an argument that coming where you were, you wouldn't have known of the stop sign, but you clearly failed to stop exiting a public driveway, which I think is going to be the same thing, a private driveway.
Those are two legally distinct offenses with two legally distinct statutes that define the offense.
Yes.
And I was not cited for that.
Well, I just made a finding that you violated that. So whether you were cited for it or not, I find that you failed to stop on departing a private drive. Fine is $90. And apply your bond to the $90. You posted a $90 bond. Under your theory, there would be no repercussion for pulling out of the cemetery without stopping, blowing through the stop sign and crashing into somebody at that intersection. You can't have it both ways. You either have to stop at the end of the cemetery or you have to stop at the stop sign, and you didn't do either one. So you posted a $90 bond. I'll leave the fine at $90. This is a civil infraction, not a misdemeanor. So the burden of proof is less. I find arguably the burden of proof has been met for the stop sign violation, but I understand your argument. Anyway, you can't do what you did. You can't just pull out of there, go through that intersection without stopping anywhere. So the fine's the same. The charge will be different. That's 257,652. The driver of a vehicle about to enter across a highway from an alley, private road, or driveway shall come to a full stop before entering the highway and shall yield the right of way to any vehicles approaching. Any person who violates this section is violation of a civil infraction. It's just a couple of sections away from the one we're in, 257,652. All right, you're responsible for that. That's what will show on your driving record. I believe it carries 2 points, and the $90 fine from your bond will apply to the fine it costs. All right. That completes our record here.
Thank you, Your Honor.
Thank you.
Are you counsel or are you management?
Just agent for.
Oh, okay. No worries then. Well, then if there's no other matters, you're all excused.
Thank you, Your Honor. You have a great day.
You
Bye-bye.
as well. 26,809. This is IMP South Lamar versus Jesse Radizowski and others. On behalf of IMP South Lamar.
Your Honor, Brian Dunn for IMP South Lamar LLC.
Good afternoon, Mr. Dunn. And do I have someone here on behalf of Jesse Radizowski?
Yes, I do have myself, and I also have Isabella on the call as well.
All right. Have you brought a witness?
Yes.
Okay. Thank you. Good afternoon to you both. Mr. Dunn, why was this case filed?
Your Honor, this is an eviction for conduct. The conduct in question occurred on or about April 14th of 2026, wherein the defendant confronted and harassed contractors performing authorized work on the premises being apartment number 332 at 809 South Lamar Boulevard, Austin, Texas 78704. The defendant allowed dogs to bark and chase workers, creating a safety hazard. The defendant then jumped a fence, physically approached and engaged in aggressive conduct, including pushing a worker and forcibly taking and throwing his phone. The defendant then returned the following day with additional individuals, escalated the confrontation, and blocked workers from leaving the property, from leaving the area, forcing them to retreat from the property from their safety. The defendant further returned back into the office and made a comment to staff that the owner would have a death on its hands if something wasn't done with respect to this matter. These are in violation of the lease, Section 10 of the lease, which provides they must follow the community policies. Section 11 of the lease, which provides that the defendant communicate and conduct themselves in a lawful, courteous, and reasonable manner at all times when interacting with any property, anybody with management or anybody associated with the property or other residents. Section 11.1 of the lease provides that that if the defendant, any occupants or guests engage in unlawful, discourteous, or unreasonable behavior, including but not limited to engaging in criminal conduct, threatening violence, or in any way that may alarm others, or behave in a loud, obnoxious, or dangerous manner, or disturb, threaten the rights, comfort, health, safety, and convenience of others. And then under 23.1, the landlord is entitled to, due to these defaults, the landlord's entitled to terminate the lease. A valid notice to vacate was delivered by email and U.S. Certified mail and U.S. mail on April 27, 2026. We are asking for possession, costs, and attorney's fees.
All right. Are you gonna call any witnesses?
The witness
No,
for
no,
this.
no, sir. The
Oh,
plaintiff has to
sorry.
prove their case. He's given an opening
Excuse
statement.
me.
Now he's got to prove it, sir. You're gonna get a chance. Mr.
Sorry.
Dunn, would you plan to call
Yes,
any
Your
witnesses?
Honor.
Okay.
I
who would
brought
be
a
your
witness
first witness?
with me today. This is Christine Shirley with me.
Good afternoon, ma'am. You were here for the beginning to hear the swear-in for statements and witnesses?
Yes.
Okay, just remember that. Go ahead, Mr. Dunn. You can ask questions of your witness now.
Where are you currently employed?
Windsor Sophomore,
And what is your position there?
Resident Services Manager.
Are you familiar with the lease records and payment history for the tenant?
Yes.
And I'm showing you a document. I don't know if I'm going to be able to screen share off of a tablet, Your Honor. I apologize. I'm going to try to.
We can authorize it. I always give a cautionary tale, Mr. Dunn. Make sure when you hit share, you're only sharing the document one, that you're not gonna have any instant messages pop up to tell you that you're losing a bid on eBay or something.
Yeah, I don't have many of those.
Well, our team's messages popped up and been like, Taylor Swift got engaged, not relevant in the middle of a hearing. I wish that wasn't a valid example, but it was.
Where is share screen?
Should be toward the bottom.
Mm-hmm.
Got like a little arrow pointing up in it, a little square.
It should be a bright green, if that helps.
Bright green. Do you see it, my boy?
Wait, do you have to start sharing?
More. There it is. So that's like that. Your Honor, it says only the host can share in this meeting.
We can authorize it.
Mm-hmm. You just need to send a request in.
Your Honor, can you perhaps bump us for a minute here and take on the next one so we can get this straightened out?
All right, Mr. Rajkowski, that means we're gonna place this case on recall. I'm gonna move to the next matter on my docket. We're gonna visit you guys in a minute. I'll just give you information. You're both welcome to turn your cameras off until you get it worked, and that way we don't all stare at you kind of with that look of confusion on your faces. All right.
Thank you.
No worries. Let us return now to 26809 IMP South Lavar versus Radikowski. I had Mr. Dunn here on behalf of the plaintiff. I had Ms. Radikowski representing herself. Or I'm sorry, Mr. Radikowski. I'm so sorry. I think I'm thinking of the actress, and that's what's happening. I'm so sorry, sir.
It's
Because it's also not spelled at
Radzikowski.
all the same way. I know.
Yeah, it's Radzikowski, but that's okay.
Sorry.
No worries. It happens often.
Okay. Not a positive thing. All right.
Distant
welcome
cousin,
back.
by the way, the other one.
Well, there's an attorney in town who was related to Patrick Swayze. Let me just say that. Yeah, because Patrick Swayze is Texan, so his family is here locally.
Yep, I tried to reach out to her a few times. We messaged back and forth, but she's a little busy.
I have a famous cousin. He's the accordion cowboy, Chris Rebuck.
Oh, also.
Doesn't everyone know him?
Yeah.
He actually got a huge website, y'all. Okay. All right. Thank you all for your patience. Mr. Dunn, how do we go about working with the Zoom fund?
I'm gonna try it again, see what happens.
Okay, let's take a look.
Entire screen. Entire screen.
You're sharing us, Mr. Dunn.
All right. I guess I'll start back over again. This is for my client. Back there.
Floodplain.
Christy Shirley. Do you recognize this document that I pre-marked as Exhibit A? And what is this document?
This is Jesse's lease.
And is this the lease agreement that's in effect through today and at the time of the incident that occurred on April 14, 2026?
Yes.
And this is for 809 South Lamar Boulevard, number 332. Is that correct?
Yes.
That's for Austin, Texas, 78704.
Yes.
Your Honor, I move to admit Exhibit A, the lease agreement.
Mr. Redzikowski, any objection to this being an accurate copy of the lease between the parties?
Nope, that is
Okay.
accurate.
Real question, just as a side note, I looked at that lease. Is it accurate that the flat monthly rent is $18.39?
I know there's additional fees associated with it.
Yeah, no, in eviction, we just care about that number C, base rent. I see $18.39. Is that accurate? I know. There's all this other stuff that they add into it. But is the $18.39, is that correct, Mr. Radikowski?
Your Honor, I am unsure. What I do know is I am all updated on rent and been paid out.
I know this isn't a non-payment case. This is about conduct.
Yeah.
I still have to know the rent if someone wins or loses to determine a bond.
Gotcha.
So I'm
Yes,
just trying to figure out what the
that-
monthly rent is. It said $18.39. Is that accurate?
That seems correct to me, yes.
All right, Mr. Dunn, is it $18.39 a month?
Yes, Your Honor.
Okay, cool. Y'all keep moving on. I'm just trying to fill in my information that I'll need regardless. Okay, so we got a lease between the parties.
Now,
And you were talking about section 11.
well, if you don't mind, I'd like to get my second document admitted, then I'll go
Certainly.
back if that's okay.
No, go ahead, Mr. Dunn. This is your case.
Do you recognize this document? What is this document?
This document is a notice to vacate.
And this notice to vacate was sent on, what's the date of this document?
April 27th, 2026.
Is this a true and correct copy of the document?
Yes.
And you are a records custodian for the property, is that correct?
Yes.
And this document is kept in the ordinary course of business?
Yes.
Your Honor, I'd like to move to admit Exhibit B, the notice to vacate.
Mr. Rajkowski, any objection to this being an accurate copy of the notice to vacate you received?
That is not the original copy I received. The original copy I received had a different date on top of that, which is not April 27th.
What was the date you received?
I believe it was May, or it was March 27th.
Your Honor, there was one that was sent before this. However, this document was sent on April 27th.
All right, Mr. Radkowski, did you receive this one as well in the April 27th?
Yes.
Okay, so admitted.
Okay. Now, under the part of the reason that we're here today is because you received complaints from contractors that work with the property. Is that correct?
Yes.
And what was some of the complaints from the contractors was that they were attacked by the defendant. Is that correct?
Yes.
Is there a video of this that you were given that you have since sent to counsel?
Yes.
Okay, I'd like to show the video of this attack.
Who created the video, Mr. Dunn?
This would be the contractor that was attacked at the time at the time of the events occurring.
Any metadata on the date on the video?
Your Honor,
I
I would
would
be
not-
more than happy to attest if it's correct or not.
Have you seen this video, sir?
I've requested it. They told me I could see it in court. So no, I've not seen it, and I'm very aware of there is videos out there. I'm Just curious to see what points of the videos they show.
All right. Let's see it. Is there audio?
No, there is no audio, Your Honor.
Okay.
In this video, do you recognize the party that hopped over the fence?
Yes.
Who is that? Okay, and do you recognize?
Mr. Dunn, I wasn't able to hear her. She's very faint.
Okay, yeah, that's the defendant.
I still can't hear her, Mr. Dunn. You're very clear. I'm not, put her, maybe switch spots with her so I can hear her.
Speak louder.
Jesse Radzikowski.
That's the person in the video.
Yes.
Ms. Radkowski, is that you?
Yes, Your Honor.
All right, go ahead.
And then
Can I see the video again, Mr. Dunn?
I can try.
Was there an ability to get a better quality?
This is the only video that we have. This is the only quality that I have of this video.
All right.
There's much more recorded than that.
All right. This is from the contractor, sir. If you've got your own evidence, you can see it, but I mean, how tall is that fence? You made some good height to get over that thing.
I was a high jumper in college.
Mm-hmm. Whose dogs are those behind you?
One of them is mine, Kona, and
Okay.
another one is a neighbor's dog, Coda, who was stuck in surgery and asked if I could let her out.
Where are you at right now when I see you walking around with the dogs? What's that field area?
That whole field area is an off-leash dog park. It's a regulated off-leash dog park.
For the apartment complex?
Correct. Yeah, at the Windsor Lamar community.
Stop sharing. There we go.
Okay.
Now back to the next, I believe it was the day or the day after in question.
was the
So
day
this would
after.
be, Your Honor, I'm directing
Mr.
this. to my
Radkowski,
client.
I'll just give you a tip. As a defendant, be silent. You do not have to assist the plaintiff in trying to prove his case against you.
Yes, ma'am.
You will absolutely get a chance to cross-examine and then present your own stuff, but like truly, it's Mr. Dunn's position. He's got to prove his case, or he's got to at least get the ball to a certain point. Go ahead, Mr. Dunn.
Did the defendant enter into the business office on premises?
Yes.
And did the defendant make a complaint to you?
Yes.
And what was this complaint regarding?
The complaint was regarding that he saw the vendor allegedly shooting a nail gun in the dog park.
Okay. And did he say anything after that?
He did.
And what did he say?
He said that he would, if he was to come back on property, that he would pop them and then we would have a death on our hands.
He being the contractor?
Can you read?
The person that he was referring to when
Yes.
the defendant said if he came back, that would be the contractor, correct?
Yes.
Okay. And
Did you believe he was credibly
Uh,
threatening the contractor?
Yes.
did
What
you
actions
believe?
did you take after that?
I'm sorry.
What actions did you take after he made that threat?
We asked him to vacate the office area, the lobby, and we reported it to upper management.
Did that statement disturb or threaten the rights, comfort, health, or safety of you?
Yes.
Did that statement lead, did you believe that in that statement that he was going to, that he might do some kind of action against your contractors?
Yes.
Okay. And that particular interaction, under the lease, under section 11.1 of the lease, are statements like that allowed? The statement in question being, you might have a death on your hands, I believe, have a death on its hands, the owner would.
The statement.
And again, you requested that, the action that you took is that you reported it to upper management and then upper management reported it to council. Is that correct?
Yes.
And we then issued a notice to vacate shortly thereafter. Is that correct? Okay. And as of today, has the defendant paid all rent?
No,
And what rent has the defendant failed to pay? June of 2026, is that correct?
yes,
Your Honor, I'd like to pass the witness.
When is rent due under the lease?
the first. That's the first.
Okay. All right, Mr. Radikowski, now you have an opportunity to question the witness.
I apologize if you felt uncomfortable with the things I said. I was in a very emotional situation in regards to conduct that happened the day
Mr.
before.
Radikowski, now the last thing I'm going to say is be cautious you don't make statements against interest when you are questioning a witness, because what you just said
Gotcha.
sounds very culpable.
Who else was with me when I was at the office having this conversation with you?
Objection relevance.
Because it was a
Go ahead and answer. Was there anyone else with him or with you present at the office?
Yes,
Who?
Do you know who he is?
yes, Kevin Friel.
And what is his relation to the property?
He was a current resident and he has moved out.
Thank you.
I'm going to go again with relevance, Your Honor.
The relevant,
Mr. Dunn.
the relevance I have is from the documents I submitted. Exhibit E has a written statement from Kevin. And
Mr. Radikowski, written statements aren't going to be admissible in court. I need a live testimony. That's why Mr. Dunn had to bring a witness. If you can get him on the phone, I'm happy to hear from him, but written statements are hearsay and there's just too many problems with it because the plaintiff can't ask any questions of that person. The same thing would be true. Where are you going? Mr. Radikowski, please don't get up and disregard the court. It's very
sorry,
disrespectful.
no, I'm
That's no
grabbing my
different than if
phone.
you got up and began to walk out of the room, right?
No, I'm sorry. You said if I could call him, so I just
I
picked
didn't
up
mean
my
right
phone.
then and there.
Oh, excuse me.
All right.
Sorry.
Okay. All right. So let's move back. What other questions do you have for this witness?
Do you recall word for word or the context of the conversation that I brought up of my frustration?
Yes,
And what was that?
the context, or are you asking for details of what you said?
Yeah, details of what I said. Do you recall any per se laws that I brought up in regards to Texas?
No,
Do you recall any thing that I brought up in regards to the process of what was happening and my frustration with the lack of accountability or seriousness of what I claimed the previous day being counted?
I do recall you expressing your frustration. Yes,
And when I said there will be death on your hands, do you recall the sentences I said before that?
Mr. Radikowski.
I recall only a few.
Okay.
It was a high energy moment, but I remember the threat.
Okay.
Okay. Any other questions, Mr. Radikowski?
No.
Okay.
Your Honor, I'd like to be heard on attorney's fees.
Let me give a few pieces of information. So, Mr. Radikowski, per your question right now to the witness, I heard you acknowledge that you said there'll be death on your hands.
I do not recall saying there would.
You just asked her what else you said after you said that. That was literally your question to her. Do you recall what else I said or after I said there'll be death on your hands?
Okay.
Okay, that is a statement against interest that proves the very allegation made by the plaintiff. For that reason, I think it is best for you, reserve your right to appeal. You're beginning to say things that I don't think improve your situation, and you absolutely can, but if you just admitted that to her, that is right there, textbook. That's a violation of the lease that would give them a rise to evict you for a threat to the tenant. If you came in and, as you just said, what else did I say after I said there'll be death on your hands? That phrase in and of itself is too much. Okay. Judgment for the plaintiff. What are you seeking for your teams today, Mr. Dunn?
$750, Your Honor.
Okay,
I'm
that
a
seems reasonable.
attorney licensed. What,
All
sorry?
right. I said that seems reasonable.
Okay.
All right, $750 plus possession and cost of court. Mr. Radikowski, either party can appeal. I recognize there's been not a money issue. It sounds like that's fine. There might be some issue with June. I'll let y'all work that one out. I think he's otherwise been just fine on it. So reasonableness here for all things considered. Also, it sounds like, Mr. Radikowski, a lot of anger and or emotion because maybe there was some concerns about the safety of the dogs in the dog park, which is bound to arise a certain level of emotion. So I can appreciate
Contractor
that.
shot nails at me and my dogs. Yes.
Yeah.
There's a lot of emotion there. That's family.
Absolutely. That's it. So
And I went to the
I'm not gonna
office
put any,
3
I'm gonna
times.
put the appeal bond equal to 1
They
month
did
of rent,
nothing.
Mr. Radikowski.
That's fine. I'll just gonna
Okay.
appeal it. It's okay.
Your
Well,
Honor, we'd like
I'll
to
be seeing you again.
request-
Hold on. Let's not
Two-
all talk over each other. Mr. Dunn, it's $750 for fees plus cost of court and possession, appeal bond of $1839. What questions do you have for the court?
we would request 2 times the monthly rent, but that's fine, Your Honor.
Okay. Anything else? Mr.
No, Your
Radikowski?
Honor.
All right. All
No,
parties are excused.
that's
Thank you
okay.
very much.
I'll see you again.
Good luck, everyone.
Thank you, Your Honor.
Thank you.
Yeah,
Stephanie, thank you
smile.
very much today as
Funny guy.
well. We'll let all parties remove and then we'll go through our numbers, make sure we got everything just as we need it to be. All right.
Court calls case People versus Kyle Pennell.
Good morning, Your Honor. May it please the Honorable Court, David Burge, Kyle Pennell, who's approaching.
Your name?
Kyle Pennell, Your Honor.
Thank you.
Your Honor, discovery is complete. We're requesting examine this matter.
Would people have their witnesses available to 16th?
We'll do our best, man.
Preliminary examination in this matter will be set June 16th, 2026, 9 a.m. before Judge Moore.
Judge, could I briefly address the issue of bond?
Certainly.
Thank you, Your Honor. Your Honor, bond's currently set in this matter at $500,000 cash surety. Understanding the serious nature of the charge, Your Honor, I have information that the victim in this case, the alleged victim in this case, not only was potentially the initial aggressor, tried to jump in my client's car. Car was the alleged weapon in this case, Your Honor. His injuries sustained were minimal. I think his toe might have been run over at worst, Your Honor. I have text messages from the complaint. He was at the casino the next night and was released from the hospital hours later. Understand, Your Honor, my client does not have a perfect record, but he's been some time since he's had any issue. He does his fiance, Your Honor, who's pregnant, is present in the court today in support of him. They do both reside. He is employed. I'm asking the court to consider at least a reduction in the current bond, again, set at $500,000 cash surety.
Response?
I can.
Does he have other, what's his record like? Because I mean, I'm having some pause on this only because at arraignment, there was a substantial bond that sometimes in and of itself can be unusual.
Are you looking through the criminal history?
Well, yeah, for some reason, his bond got set at $500,000.
No.
And Mr. Burgess, properly so, is asking for, in essence, a reduction or his release, but I'm not hearing anything from the people that is telling this court that a $500,000 bond is
What I have.
appropriate, and but somehow at arraignment,
I wasn't present, Your Honor, but
no, and I know, but the people were.
all right.
I'm trying to figure out why was this set at $500,000 if they're gonna leave it to my discretion, because
I see that there is a bench warrant for a probation violation where bond was denied.
so, okay.
And, the charges are assault, attempted murder, assault with a dangerous weapon. I am seeing, several cases within the last few years, not all of them have gone to adjudication. But that they are either assaultive or firearms.
Is he held on the,
Probation violation, Your Honor.
right,
Yes.
Your Honor, yeah, he does have a, I think he's held, but if he's able to post bond, he could address that issue with the sentencing court.
Bond is denied in that.
who's that before?
It was like 14.
So his bond is denied out of 14B.
Yeah, probation judge Washington.
I think so.
I'm not sure why, Judge. I mean, it's a misdemeanor matter.
Has he gone over, does anybody see a date scheduled for him at 14B? Thank you. And
You know, she's gonna have the answer.
so he's set to be seen June 25th. You have this on the 16th. His bond isn't gonna be changed there, but
Just facially seems excessive, Your Honor.
it stopped piling on.
Fair enough.
I'm gonna grant a reduction. I do consider this charge as serious, but he's not gonna be going anywhere. It seems at this point. I'll modify his bond. I'll modify it to $100,000 cash surety.
Thank you, Your Honor.
All right. Thank you.
All right. All right.
Clerk calls case people versus Justin Mosier.
Morning, Your Honor, bringing people.
Well,
The judge.
state your name for the record, sir.
Justin Moser.
Thank you, Judge. We would like to adjourn this matter for further negotiations, and I believe my client would like to respond if possible, Your Honor.
Preliminary examination will be adjourned June 18th, 2026, 9 a.m. As to bond.
Thank you, Judge. I recall we were here a couple of weeks ago,
I do.
at which point my client went over to community corrections to test. He believed he was
Yeah.
playing.
Yes, he did.
He did not come.
We all got a surprise.
Yes, we did, Judge.
Yes, we did.
It's Judge. Stated that he had taken an appeal he wasn't supposed to take for persistent back.
Yeah, I remember the story.
That's what he said.
Yes. And I understand what he said, and what I did not believe, but go ahead.
Fair enough. He's been in jail for the past 2 weeks, Your Honor. Other than that, he has been compliant with his terms of bond. He doesn't have any problem drug testing and confident that should the court allow him another opportunity, all of his future tests would be clean. And if you did believe his story about the pill, he would not take any other pills that were not prescribed to him.
Is that still his story? Because I would just tell you, if that's still his story, I don't think I can trust him to release it.
Is that still your position on how the test came back positive?
I took a pill and I knew it was an opiate pill.
Oh, so now we know it was an opiate pill.
Story had
And
changed.
it has,
Yeah.
and I'm 100% sorry. I would be more than happy to pass tests with flying colors, 2 a week, many you want to.
Oh, don't tell me that.
I think he means it, Judge. He did indicate on the phone call we had that he is the sole caregiver
for his children and his mother. His girlfriend does work full time and she provides for the household. She's been struggling for the last 2 weeks as a result of his incarceration. He said he'll test and do whatever the court needs him to do, clean, and prove to the court he'll be clean if the court will give him another opportunity. So that's what he's asking for. Apologizes.
Why didn't you just tell me the truth at the beginning?
You know, sir, I'm scared like heck to be in the system. It's the first time I'm in this system. And I wish I was more forthcoming and upright.
Yeah, how'd that work for you?
It didn't work good, and I'm
Yeah.
fast about the system, and you're not playing around here, sir. So I'm learning very quickly, and
Okay, go ahead.
I don't want to incriminate myself any further. I'm sorry for what I've done. I'm deeply, deeply sorry, and I'm trying to go through all the rungs of the ladder to complete not only this little junction here, but to get on the straight and narrow for the rest of my life, sir.
Any response from the people?
I wouldn't have an objection to the court releasing him with some fairly strict testing requirements.
Everybody's so nice to me.
It's a good day, Judge.
So he's admitted to the violation.
Yes, Your Honor.
He did fine. How long have you been in?
2 weeks, Judge. Two weeks, what?
Yes, sir. Yep, 2 weeks.
Oh, yes, sir. Got it. How many times a week you think if I release you, you should be tested so I can make sure you're clean?
Sir, I'll leave that determination up to you. I'd be willing to do 1-2 times a week, up to your discretion.
I've said as many times before.
He said at least
When
one or I think
Go ahead.
that is at least 1 or 2, up to the court's discretion, up to the minute you think about it. So if you want 7, I think he's saying he'll do 7, Judge. What you're saying?
That's what I'm saying.
Drink?
No, sir. I have in the past. I'm not currently drinking.
I think what he means is
Okay.
I'm willing to blow. I'm willing to blow as well. Test for drugs and blow. So
I think what he means is he has.
This is a confessional. It's not. Asking.
Have you had a drinking issue in the past? What judge is asking.
I have drank in the past. I'm not currently drinking now, and shortly before this, I wasn't drinking as well.
What's your drug of choice?
Okay.
Is it drugs? Is it alcohol? Is it both? And so that's what he's asking you. Is have you had a problem with alcohol in the past?
Okay, what I'm gonna do in this case is I'm going to adjourn this out to the 25th as opposed to the 18th at 9 a.m. Previous bond is reinstated. He admits to the violations. I will sentence him to 14 days Washington County Jail, credit 14 days served. I'm reinstating his previous bond of $10,000 personal recognizance. I will also order and signing a new order that defendant is to report to community corrections for 2 times per week testing.
So much, Judge.
Thank you.
Thank you, Judge. I appreciate it, Your Honor.
Courthouse case, People versus Justin Heat.
Where to go for this?
Read. Is that your name?
Justin Heaton.
All right. Mr. Heaton, you're here without counsel. First question I have for you is, do you wish to be represented by counsel?
Do I have a standby attorney?
Pardon?
Do I have a standby attorney?
I'm not gonna grant you a standby attorney. Do you want to be represented by counsel?
Um, today at this moment, no.
Okay, are you sure about that, Mr. Eaton? And let me just tell you why, because you, you have another case, it's really not in your name, but about the place that you live. You know that? An eviction case? All right. Um, did you talk to an attorney, Travis Gagne, at all? Travis, you remember him?
Not that I'm aware of.
Pardon?
Not that I'm aware of.
Okay. Do you remember the police coming by your place that you live? And talking to you? Mr. Heaton, listen, I mean, you have the right to represent yourself. I don't, I can't force you to get an attorney. Do I think it's in your best interest, given everything that I know? And usually I don't know all of this about people's cases, but I think it might be in your best interest to have one. But if you don't want one, you can continue to try to represent yourself. Okay.
Can I speak with an attorney before I choose for them to represent me today?
Okay, that's progress. Let me ask you this. Did you meet with somebody from CMH already? Do you know? Did somebody come and talk to you about treatment or anything? That would have happened maybe yesterday? You don't remember that?
I'm choosing not to respond to that.
Okay, no, that's fine. You don't have to. I'm just trying to figure out what, because part of that relates to the other case. Okay, that's why I'm asking. I'm not. All right, so let me ask you this, Mr. Eaton. You want to talk to somebody before you decide? So if I sent you back and let one of the public defenders come back and talk to you, you'd talk to them at least before we go ahead? Mr. Heaton, that's kind of, hang on, you don't have to respond to me. That's kind of what you asked me to do. So what I'm going to do is I'm going to ask them to take you back. I'll send somebody back from the public defender's office, talk to you a bit, and then we'll bring you back out, okay?
All right.
All right, thank you. For the past that, man. Doing speech speakers off the phone. Can you make sure somebody gets back there? You got 3 more cases? So you're not gonna do what I asked you to do? What? So no, what you want me to be? You go sit up there and challenge me? You're supposed to be both places. That's what I want.
I'll do that, Judge.
Yeah, all right. I'm not saying you have to go back. I'm just saying somebody. Court recalls the case People versus Heath.
I'm sorry. No problem.
Ready, Judge. Court shall feast first assistant public defender appearing with Mr. Heaton on file number 26 F30532. That look right to you, sir? That's the cut case number you want me to talk about, right?
This is the one, work next to the information.
You know information. That's the case number right now.
Okay.
The right one, right? That's the right case number? Okay, state your name, please, for judge.
Justin Heaton.
Thank you.
Thank you, Judge. I did have an opportunity to speak to Mr. Heaton back in holding. We had a good. Mr. Heaton wanted me to appear briefly and ask the court for my appointment temporarily. I told him that it's not generally how it goes, but he said he'd like me to help him through today's hearing and then go from there, Your Honor, if the court will allow.
I will indicate this now a public defender case.
Thank you, Judge. In speaking to Mr. Heaton, he wanted to make sure which case number he was here on, and that's why I read that case number.
Number
Yes, Judge.
0532 case.
Okay.
All right.
Well, that's the case number that we're here for, Mr. Heaton. He has indicated, Your Honor, that he would like the court to consider amending his bond information and the court paperwork, he says, so that the court may consider releasing him. Today is what he wanted me to request, Your Honor. He said that he has no problem addressing this case, but he'd like to do it from home and not from in custody. I spoke to Ms. Feltus about this briefly, and I believe she indicated that the people were contemplating moving not to have to do it while in custody. So he wants the court to consider his release.
Okay, so quite honestly, I don't think opposed to his release, but I'm not going to do it today.
Okay.
Okay. What I will do, instead of adjourning it out 2 weeks, I'll just adjourn it out 1 week.
Okay.
And then I'll continue his bond. And what I would like to see is potentially that but I'll have my staff provide the name of the attorney for the trust that basically owns the house that this individual lives in.
Okay.
Okay. And so somehow or another, and what I was trying to explain to Mr. Heaton, that case is before me on my
civil side
landlord-tenant docket.
Okay.
So while I don't oppose that, I know there would have to be conditions regarding his release back to his home. So hopefully we can get that all worked out, talk to the counsel for the Heaton Trust, and then we can get him out of custody in there. And back home.
Thank you so much, Judge. Mr. Heaton, do you understand what the judge said?
Well, I have a question.
Okay, please.
So the conflict is in the location rather than this current case.
The conflict, what do you mean?
The conflict that we're looking at does not pertain to case 0532 or
I'm not sure what you mean by conflict, but I'll just say this. I'd like to get you back home to your home in Chelsea, right?
Well, that's not where I was apprehended.
Pardon? That's not where I get that's not where you're apprehended, but that's where you live. Right? And so I'd like to get you back where you can reside there. But I know that there are impediments between the homeowners association, the trust that owns the condo, and then you're residing there. I know that those exist. What I'm hoping is by giving them the number to the
trust attorney,
that some of those issues can be resolved, and then you can go back there under certain conditions. All right, so that's what I'm going to do, and I'll just put it out a week, and let's do that, and I'll make sure you have those numbers.
Thank you very much.
All right, thank you.
You can go to deputies.
That's the last jail.
That's the last jail. Guys, thank you. You'll pass along the information I was giving to Mr. Okay. Court calls case People versus Gregory Huff.
On behalf of the people, Your Honors.
Assistant Public Defenders Act venue with and on behalf of Mr. Huff, who approaches.
Your Honor, we were requesting an adjournment in this matter, and there's also a bond issue to address.
Yes, I will adjourn the matter to the 25th. 2026, 9 a.m. as to bond.
Came to my attention that while Mr. Huff was in custody after he had been arraigned, he was arraigned on the 23rd. These calls were made on the floor. Her listed number. In these calls, I had a couple concerns given that people saying I need to get out of here, I'm going to lose my job. They want me to get out. So I had concerns given the nature of these calls. And the fact that there was contact made 3 days after he was arraigned with the victim.
Your Honor, Mr. Huff would admit to this violation. He would admit to calling the witness while he was in custody, or the complaining witness while he was in custody. We would ask to be heard as to bond and or sentence.
All right, Mr. Allen, go ahead.
Your Honor, Mr. Huff does admit to these violations. He was in custody for 6 days from May 22nd until May 28th before he bonded out. During that time, Your Honor, he did not have any of his medications with him. He did not have his blood pressure medication, he did not have his heart medication. So his blood sugar spiked to dangerously high levels. He stated to me that he was not in his right mind. He was it was in a situation where his decision making was affected by his health conditions being exacerbated. So he stated that once he has been out, he has once he has been out, he has been compliant on bond. He's on a tether. He is staying with his stepdaughter, Your Honor, and there's been no tether violations or anything to my that I'm aware of. Additionally, Your Honor, he has these allegations were our office found out about them this morning. I informed Mr. Huff of the possibility of him being remanded today. He did not run, he did not flee the courtroom. He sat right there this entire time knowing that he could be brought into custody, Your Honor. So he is just he's requesting another chance, Your Honor. He understands the nature of these charges and that he will have no contact whatsoever with the complaining witness. I believe she is here as well today, although I don't know that she's going to speak or anything like that. But and then additionally, Your Honor, he is very concerned about losing his job. He has severe health issues. His wife, this is the complaining witness in this case is his wife of 20 years. She also has health issues. She has cancer, is my understanding. And so he is worried that if he loses his job, they will both lose health insurance. And so for that reason, Your Honor, we're at the court's mercy. And then lastly, Your Honor, if you were to remand Mr. Huff into custody, he would be requesting just a day or a few hours so he can go and get his medication so that this situation does not happen again while he is in custody. And then lastly, Your Honor, he has been attempting to go to community corrections and test. He was arraigned over the weekend by Magistrate Wang, and it appears that there was some issue with getting the community corrections test over. So he has been trying to go there. He has been twice, he has called. And as of right now, they stated that they did not have an order. So if Your Honor were to allow him to not be placed into custody, we would request that an order be sent over to community corrections so that he can test. Thank you.
Send this out to the 25th. I don't need any response to that from the people. Depending on having admitted to the violations, I'm going to send it to 10 days. I'll give him credits, but at this time, defendant is removed.
Thank you, Your Honor.
All right, State of Michigan versus Lindsay Dowland, file 26-44414-SD.
Judge
Mike
Mike
Stack?
Klexit. Yes, Your Honor. Mike Klexit on behalf of Ms. Dowland.
All right, thank you. This is set for a status conference. Do we have a resolution of this matter?
We do, Your Honor. Ms. Dowland is going to be pleading no contest to count 1 OWI second as charged in exchange for dismissal of count 2. And I wouldn't call it a plea agreement because it's not, Judge, but Mr. Fortier and I have been discussing this case at some length. And I would say we have kind of a joint or mutual recommendation for the court's consideration.
Do I need to hear that now, or you want to wait till sentencing?
I think we can wait, Your Honor.
All right.
The plea agreement is just no contest to count 1 and dismissal of count 2, Judge.
All right. So, Ms. Dowling, you understand that count one is operating while intoxicated as a second offense, which is a higher level misdemeanor. It's a $200 to $1,000 fine, up to required 5 days to 1 year in jail, community service, rehabilitative programs, cost of prosecution, and all of that. Do you understand all of that?
Yes, Your Honor.
And then count two would be dismissed. Is that what you want to do?
Yes, Your Honor.
If you do that, and there's nothing wrong with doing that, but if you do that, you would be giving up your right to have a trial and all of the things that would happen at a trial. Do you understand that?
Yes, Your Honor.
Those things that happen at a trial include the right to have a trial in front of a judge or a jury, the right to be represented by Mr. Klegstad at that trial, the right to see, hear, and question all the witnesses against you, the right to present your own witnesses and evidence and get a subpoena from the court to require your witnesses to appear and testify. In addition, you'd be giving up your right to testify or your right to remain silent and not have that silence used against you. You'd also be giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt and to have that burden rest with the prosecutor at all times. Finally, you'd also be giving up your right to automatically appeal. Do you understand all of those rights that you'd be giving up?
Yes, Your Honor.
Do you have any questions about any of those rights?
No, Your Honor.
Do you wish any additional time to speak with your attorney about what you're doing today?
No, Your Honor.
Knowing all of that, do you still wish to enter your plea today?
Yes, Your Honor.
I'm going to need to take some testimony from you then. Would you raise your right hand so I can swear you in? You swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right, go ahead and put your hand down.
I think this was supposed to be a no
plea
contest
agreement,
plea.
has anybody offered you anything or threatened you in any way to get you to plead?
No, Your Honor.
Are you doing this of your own free choice and free will?
Yes, Your Honor.
All right. The charge in count one, operating while intoxicated, second offense, reads as follows. It says that on or about March 6th of 2026 in Otsego County, that you did operate a vehicle upon a highway, that is Alexander Road, while being under the influence of an alcoholic liquor. Is that true?
Yes, Your Honor.
I'm sorry, I wasn't able to hear that.
Yes, Your Honor.
All right. What vehicle were you operating at that time?
I believe it was my Ford Explorer.
Judge, if I might interject for a moment, I believe she's testifying from what she learned after the fact. The reason for a no contest plea is she does not recall the incident itself.
All right, I apologize. You did say that ahead of time. So what would you like me to use for the no contact plea?
Judge, I think she can testify to an awareness of that. We could also use the police report or an affidavit of probable cause. I apologize, I did not have the foresight to provide that to the court.
Can we mute Mr. Aversane?
Mr. Aversane?
Yeah.
Could you mute yourself, please?
Hello.
You need to mute yourself, Mr. Aversane.
Is it working?
No, it's not. You got it now. All right, we're good. All right, Mr. Klegstad, I do have an affidavit of probable cause. Do you agree, you and your client both agree that I can use that as the factual basis?
Certainly, Your Honor. Thank you.
Mr. Fortier, any objection to that?
No, Your Honor.
All right, let me read that real quickly. All right, the affidavit of probable cause was submitted by Officer Booten from the
Should be the Sheriff's
Department. Yep, thank you. Indicates that on March 6th to 26 at northbound I-75 near Alexander Road, he responded to the report of a car that had run off the roadway and hit a tree. He identified the driver as Lindsay Dowland. There were other witnesses that identified her as well, being the driver. She admitted to driving, stated that the slush had pulled her into the ditch. However, the officer noted that there was no slush on the roadways. He observed her to have almost falling out of the vehicle and trying to get out, had to use the door for balance. She was stumbling. Was unable to perform appropriately the standard field sobriety tests, unable to keep her balance. She used her arms for balance, incorrect number of steps. Had to discontinue the tasks due to her almost falling down. and had a PBT with a result of 0.180, all of which I believe supports her operating while intoxicated on a public highway within the city, within county of Otsego on March 6th of 2026. As to the prior conviction, Mr. Klegstad, does your client stipulate to the prior conviction on or about December 4th of 2025, operating while intoxicated in the 87A District Court?
We do, Your Honor.
All right. Then I do find the no contest plea to be rendered appropriately, given her lack of knowledge of the incident, the accident, and the intoxication. And I do find the plea to be knowingly, intelligently, voluntarily granted. The facts support the OWI second, and so I will accept it. All right, Mr. Klegstad, I do see that a substance abuse assessment has been done from Up North Psychology PLLC. Mr. Fortier, have you ever received a copy of that?
I have, Judge.
I've gotten it, but I didn't have a chance to review it yet, so let me do that real briefly. All right, I've had a chance to review the substance abuse assessment provided by Up North Psychology. And we will move to sentencing at this time. Ms. Dowland, I'm going to give both the attorneys an opportunity to tell me what they think should happen. And once you've heard that, I'm going to give you an opportunity to tell me anything else that you want me to know before I decide what to do. Mr. Fortier, your comments?
So, Judge, this one, I think it's incredibly clear that Ms. Dowland has a drinking problem. She had just completed probation successfully and was early discharged for an OWI that occurred at Gaylord High School. That same day, she decided to gather more alcohol as a quote-unquote celebration, wherein then she decided she wanted to drive, went off the highway and struck a tree with her vehicle, and she actually struck that tree hard enough to break it in half. It was a pine tree, albeit not a fully grown pine tree, but still hitting it with enough force to crack it and break the top half of the tree off. I think it's scary that there's a person like this driving around on the roads. To have picked up your second offense literally the day that you're discharged from probation is concerning. And I will say, to her credit, Mr. Klagstad has provided that she's been doing voluntary scram monitoring. She's been attending her AA, all of these things. So hopefully that is a sign that she's going to start taking this problem seriously. Part of Mr. Klagstad and I's discussion was with respect to kind of what we would recommend as a sentence in this one. And in looking at Michigan statutes, specifically MCL 771.2 subsection 1, allows the court to sentence individuals charged with misdemeanor offenses for a period of probation not to exceed 2 years. And I think based on what kind of has gone down, the timing, and kind of what the projected treatment for Ms. Dowland looks like, I would ask the court to consider exercising its discretion to sentence her to a period of 18 months of probation. That she complete the educational courses outlined in the evaluation, which I believe were the victim impact panel and the alcohol highway safety class. I would ask that the court order she continue with any outpatient counseling services that she's currently engaged in, sign any necessary releases for probation to be able to monitor her progress, that her vehicle be immobilized pursuant to statute for 90 days, and that she serve the mandatory 5 days in jail under the second offense. And then I would leave it up to the court as to whether or not it wants to add any more work camp for her after the fact. And then there is a $300 reimbursement request to the sheriff's department.
Thank you, Mr. Fortier. Mr. Klingstad, allocution.
Judge, candidly, this is a tricky case to allocute for the reasons that Mr. Fortier spelled out. The timing of her offense is about as bad as timing could be. That being said, Your Honor, she was flawless on probation. She's complied with bond recommendations. She's attended AA daily. And it was important to her that this court know that she was not drinking, that she was not using, and that's why she participated in voluntary scram testing. She does want the court to know, while she does not remember taking it that particular evening, she did have a new prescription for sleeping medication, Ambien. And there's some thought, I think, that it makes sense that Ambien plus cold medicine plus alcohol could result in the lack of memory or knowledge or understanding of what happened. That being said, Judge, she does not dispute that she was driving or that she's intoxicated. She knows that both of those things were true. Judge, one thing Mr. Fortier didn't mention, all the parties spent a lot of time considering sobriety court in this case, but the obstacle for Miss Dowland that she can't overcome is that she's got a great day job. She's got 26 years with her employer. I don't know if she wants me to talk about that employment too much, but she's just a few years away from vested benefits. And sobriety court or a significant jail term would very likely derail that positive thing she's been working on for nearly 30 years. To that end, Judge, I think Mr. Fortier and I, and hopefully the court will agree, that just because she's not a fit for sobriety court, that doesn't mean that we can't mimic the accountability with a more robust probation than we would normally ask for. Given that, Judge, I do think that the recommendation for 18 months of probation is appropriate. We agree with the restitution and the other recommendations following the treatment recommendations in the substance use assessment. We'd also ask that the court order continued use of the previously voluntary scram at probation's discretion. I think that would be appropriate. That being said, Judge, the 5-day statutory minimum, Ms. Dowland understands it. It is still a hurdle. While we're not going to ask you to deviate from that, I did want to inquire whether there was any possibility of weekends in jail or something like that. That being said, Judge, she's prepared to make the arrangements she has to make to hopefully keep her career on track.
Thank you, Mr. Klingstad. Ms. Dowland, is there anything that you want to say before I decide what to do?
I would just like to apologize to the court and to everybody for my actions. It was a mistake to celebrate getting off probation. However, it was ill-intended. I had no intention of driving. I don't know honestly what happened, but I do know that I was behind the wheel of my car. However it happened, it is my fault. And not only could I have not survived that incident, there could have been somebody else on the road that was involved. So I take full accountability for that. And I'm happy to follow the court's recommendations to make sure something like that never happens again.
Ms. Dowland, I don't have any reason to doubt what you just said to me. But it is also very apparent to me that you learned nothing on your previous probation. You catch a drunk driving, you get off probation early, and the same day you go out and buy a 6-pack and drink 4 of them. I can believe that in combination with the cold medicine and the Ambien, that it knocked you for a loop. And I don't doubt that you're telling me the truth, that you don't remember anything that happened. But you're a guided missile with no homing system. You could have just as easily been sitting here today having killed someone. I can't have that on the roads. I would guess from the fact that you've been in the same line of business for 26 years, that you're a good employee. I would guess from the fact that you got off probation early that you are accountable when you're not drinking. I think that you do a number of things very well. You present yourself today very well. You have taken appropriate actions with the help of Mr. Klegstad to position yourself for me to not have to put you in jail for a very long period of time. So I have to believe that you have some very, very good qualities. But you and alcohol in any amounts cannot be together ever again. And I'm sitting here wondering, why don't I just throw her in jail for 15 days? Because that's what this screams to me that it needs. In my view, the minimum amount is when you've had a prior conviction 6.5 years ago, so that you just barely squeaked in under the 7-year time limit for that. You weren't off probation 24 hours and you're back doing the same old again. And you did it so bad that you smashed your car up and had no idea what you were doing. Woke up in the drunk tank, as you put in your sobriety or these substance abuse assessment report. I can't tell you how disappointed that makes me feel as a judge, that someone in my county, after they've gone through the program that I told them to go through, would get back out and put the rest of the county members at that level of risk of harm. It just boggles my mind. Tell me why I shouldn't put you in jail for 15 days.
Your Honor, to be honest with you, I think I'm sitting in jail for 15 days, although I'll take the punishment that you give me. There's not a lot of interaction there. And honestly, these last 90 days of going to AA, when I was arraigned, you said go to 90 and 90, and I did. I completed my 90th day today. And honestly, I think those have been more educational and more helpful than any amount of jail could really honestly do.
So what have you learned?
I learned patience, and I learned one day at a time, and I learned that I will never drink alcohol, because whether I can have one drink and stop or not, I will never get to that blackout stage. I will never get to that next day concern and regret. And I like having a clear head. I like my position in life, or like where I'm at. My daughter's on a good track. I'm on a good track. Everything has been great these last 90 days, to be honest with you. Everything is moving forward. Everything is wonderful. But I'm definitely going to take the consequence that you give me, because I did get behind the wheel that night, even though I don't remember doing it.
So why didn't you learn that the first time through?
It's not that I didn't learn it, Your Honor. I thought we were home for the night. We had the radio playing. It was 4:30. The sun was out. And we were just happy that, okay, the daily reporting, the calls, like, we're just going to have 2, 3, 4 drinks, cook dinner, and sit home and watch a movie. I don't remember after dinner time with all the cold medicine. I don't recall, but I was told by my company that an argument pursued. And then I woke up in the morning. But there was never an intent to go to a bar and drive home. I was home. I was with company. It wasn't that I was looking to get drunk, Your Honor. I apologize for having any drinks, but the second time around, I don't plan to have any ever.
See, that's the insidious nature of alcohol. It makes you think that you need it to have a good time. and then it jerks the rug out from underneath you and causes you to have to go through something like this where I'm making you cry in front of everybody else on TV. Right? I mean, it's just a lie. That's all alcohol is. You didn't need alcohol that day to help you celebrate.
No, I did not.
There was nothing in the world that you needed. You were happy. You were having a good time. Things were going great. You got off probation early. Life was good. And you went right back to the old way of thinking. I got to have alcohol to help me celebrate. There's nothing in the world that alcohol helps you do. It's a liar. That's all that it is.
Judge, I did not get the impression that you wanted to hear from me anymore, but might I make just one brief comment?
Because you asked so nicely, Mr. Clegstad, go right ahead.
Thank you, Your Honor. I just wanted to say that in discussing this with Mr. Fortier, it certainly was not our intention to put the court in a position to give Ms. Dowland a pass, so to speak. I think, I know speaking for myself, I think Mr. Fortier's intention also was that there's no reason the radical accountability of sobriety court can't be achieved another way. And I think that's what we were looking for here, that an extended duration, more time, more accountability, that perhaps we can achieve a different result than we might normally get me asking you for 12 months or 6 months of probation or something like that, you know, with color. I've said enough, Your Honor. I think you know what I'm getting at.
Mr. Clegstad, you did a wonderful job in this case. Don't not pat yourself on the back. So you positioned your client, you've positioned your client as well as any attorney possibly could have. And you've done it for the right reasons, which was you tried to help her as a person first, and then as an advocate in the law second. So I don't have any problem at all with what you've done. It was good advocacy. It was good for her personally to go through those things, in addition to the 90 and 90 that I asked her to go through as a bond condition. So I don't have any problem at all with how you handled this and where you positioned it. But I needed her to understand the level of disappointment that I had as a judge and the worries that I have as a judge. Every time I put somebody out on the street, because I'm signing my name to these things. I'm saying she has passed our probation. She is done with probation. And then that same day for her to go out, it's almost like she's thumbing her nose at the system. And I just simply can't have that. Not because it hurts me personally, but because it endangers the county that I've been sworn to protect. And I simply can't have that. The county depends on us in the system to do our jobs correctly, to keep it as safe as possible. And this was not safe in any way, shape, or form.
Heard, Your Honor. So
I'm gonna kind of go along with where you're going instead of where I'm going, but I'm gonna change it slightly. So here's what we're gonna do. I'm gonna put you on probation for 2 years. After you've completed a year, you have the right to ask for me to put you off of probation if you've successfully completed things. I'm probably not gonna do it the first time you ask. Okay, once bitten, twice shy. But I need you to know that I don't think it's necessary, unless you act inappropriately, to necessarily stay on for 2 years. But I'm going to reserve that right to keep you on for 2 years. There's a crime victim fee of $75, a justice assessment of $50. There's a reimbursement request for $300 to the sheriff's department for their investigative costs. There is $300 in court costs, a local fee of $15, and I'm going to up the fine a little bit simply because it's second time through that fast has to go. Yeah, it has to be some teeth to it. So there is a $300 fine as well. Let me help you with what that all adds up to. Oh, there's also $720 in probation oversight fees. So It's a total of $1,760. You can pay that over the course of probation. You may perform community service in lieu of some of the fines and costs at the discretion of the probation office. You must enroll in and successfully complete the treatment and educational programs outlined in the substance abuse assessment. That includes outpatient counseling, how often are you going to, you did your 90 and 90 in AA, right?
Yes, sir.
How much do you think that you need per week to stay on the straight and narrow?
I would really like a break from going 7 days a week. Could we maybe do 3?
I'm gonna do 3 times per week for 90 days and 1 time per week. That's just to kind of keep you cognizant of what the issues are, and hopefully you'll be able to give back to other people in your position. You can be a strength for the community in that way, so that you can say, here's what happened to me, don't let it happen to you, kind of thing. All right?
Yes, Your Honor.
All right. The recommendation in the substance abuse assessment was for the alcohol highway safety program and the victim impact panel. I think that's now covered under a program called Prime for Life. So I'm going to send you to that, but it's basically the same thing. It's educational and helps you understand what you could have done to others. I think it will help you in your mentoring of others in the program as well, so that you can help them understand what's going on. We're going to do drug and alcohol testing at the discretion of the probation department. No entrance into a business where alcohol is served by the glass. That means no bars, even if they happen to serve food. You can go into a restaurant that happens to serve alcohol, but you may not be in the bar portion. And obviously, while you're on probation, you may not have, buy, or consume any alcoholic beverages. I'm going to indicate that Scram may be used at probation's discretion. If they think that you need it, they'll put it on. If not, they'll leave it off and you'll be able to deal with it that way. There is a mandatory minimum of 5 days in jail. I'm not going to break it up over a weekend. I don't think it's appropriate to do so. This was, I think I probably should have put you in jail for longer, but I'm not going to, because I did the probation longer. And because I think that you are generally a good person. You just thought that you could deal with it on your own, when now you know you can't. And I'm again taking a chance on you to do the right thing. So you're going to go to jail. When would you like to report?
I'd like to report today, Your Honor.
All right. Today is Thursday, June 4th, 6 o'clock appropriate?
Sure, Your Honor.
All right. Report to the Otsego County Sheriff's Department to be housed in the jail for 5 days, starting at 6 p.m. tonight. You'll get credit for today and be released 4 days thereafter. Do you have any questions for me?
No, Your Honor.
I trust that this is enough to have you stop in the future, right?
Yes, sir.
All right. Go and sin no more. Thank you.
Go and sin no more. Yeah, he said that. That's exactly where I got that from. I couldn't believe it when I heard it. Go and sin no more. Wow. And hey, I gotta give it to that last lady. She took it on the chin. She was ready to go right now today. We don't see that a whole lot. There was a whole lot of accountability going on with that one. I hope I have high hopes that she will get through, make it by one day at a time. All that good stuff. Sin no more. Wow. What a way to end it. We started things off kind of slow, but interesting in my opinion with the civil case. You know, the guy who decided to take a traffic ticket to a formal court case. That was an interesting bench trial. I like to see that kind of stuff. We kept in with the civil matters with the Justice of the Peace Holmes there, and the crazy guy who jumped that fence like nothing. Wow. That's all I have to say to that. And while I'm saying wow to things, hold on. Wow. Old Squishy Gardner, thank you for coming by, you OG. And thank you so much to Michelle Goes Live, Steven, and Karen. I can't pronounce your whole name, Steven. It's just not in there. Rhonda, great to see you. Shiloh, I hope you're feeling better, Rhonda. Mama, Allison. I don't even know. I can't read all these names. There's too many. They're all amazing. They're wonderful people. Eileen's here all the time. Look, there's OSG Court Watch. The original Gardner himself. Yes, ladies and gentlemen. So proud to have him in. And Hector Cam Clips, I saw him floating around here someplace. Courtroom Files, saw you floating around there. Saddle, good to see you. Dobby, good to see you. Mary Beth, good to see you. Mull, good to see you. I feel bad for saying some of the names and not saying all the names because, you know, I don't know. I'm just Lone Wolf Oosel. I do this like every single night, 8 p.m. Central Time, 9 p.m. Eastern, same Wolf time, same Wolf channel, where I gather together some of the best court cases of the day, and I show them right here, live, where we can have a live chat about it. Sometimes maybe I put those chats on the screen, and we have funny little conversations in the side chat. It's amazing. You should all join us all the time, every night. Thumbs up, like, comment, subscribe, all that good stuff. I think I'm supposed to say all that type of stuff. When I'm not live, come back and watch the playlist like I am live, because that helps the channel. Oh my God, that. Ladies and gentlemen, it has been a pleasure. We will have another one tomorrow. It is the last day of the week, and then we got Saturday coming up where we'll review some of the best cases that we weren't able to get to during each night, every night. Night Animal TV. Great to see you. Oh my God, it's that time. I love you all so very much. I'm your Lone Wolf Oosel, and I am out. I mean, I really shouldn't act like I'm not going to just come back and talk anyway. I mean, it's like, what's going to happen? But I got to hit my time mark. It's just what I do. But I love sitting here watching the chat. But look down there. I got nothing else. It's just blackness down there. God. Thank you, Squishy. Thank you. I love that wind down music too. And more than anything else, I love to come and share the gospel of Ferris Bueller's Day Off. Ladies and gentlemen, there's nothing else here for you. You ain't got to go home, but you know, you can't stay here. Well, I guess you could. Go watch a different video on the channel. We're not redirecting anywhere tonight. Maybe go watch some OSG. I don't know. Nah, go watch some of my other playlist stuff. Nah, I'm kidding. Go watch it all. It's all great. Arr! Oh, no, that's not the correct outro. The correct outro is bye. Don't wait for the white circles. You're telling on me. I'm not. I'm not gonna come. Wait. I did it.